Health Insurance Portability and Accountability Act. Protecting clients' confidentiality has always been an important responsibility of nursing. Recent changes in the laws regarding privacy have implications for healthcare providers and organizations. The Health Insurance Portability and Accountability Act of 1996, HIPAA, is the first nationwide legislation to protect privacy for health information. It is important to be aware of identifying information that is protected under HIPAA but may not be initially perceived as health information. Examples include Social Security number, name, address, phone number, email address, and fingerprints. Age should also be a consideration because age can become an identifier in the population older than age 89. The Health Insurance Portability and Accountability Act, HIPAA, describes how personal health information, PHI, may be used and how the client can obtain access to the information. PHI includes individually identifiable information that relates to the client's past, present, or future health, treatment, and payment for healthcare services. The Act requires healthcare agencies to keep PHI private, provides information to the client about the legal responsibilities regarding privacy, and explains the client's rights with respect to PHI. The client has various rights as a consumer of healthcare under HIPAA, and any client requests may need to be placed in writing. A fee may be attached to certain client requests. The client may file a complaint if the client believes that privacy rights have been violated. HIPAA includes 4 specific areas. 1. Electronic transfer of information among organizations. Instead of each health provider using its own electronic format to transact claims, etc., HIPAA implements a national uniform standard to simplify such transactions. 2. Standardized numbers for identifying providers, employers, and health plans. Instead of each healthcare organization using different formats for identification, HIPAA published standard identifiers. For example, an employer's tax ID number or employer identification number is the standard for electronic transactions. 3. The security rule provides for a uniform level of protection of all health information. This rule requires healthcare organizations and providers to ensure the confidentiality, integrity, and availability of all electronic protected health information, EPHI. 4. The privacy rule sets standards defining appropriate disclosure of protected health information. This rule also gives clients new rights to understand and control how their health information is used, example, how to access their medical records, restrict access by others, request changes, and learn how they have been accessed. Examples of HIPAA compliance and nursing practice. Store charts in a secure, non-public location to prevent the public from viewing or accessing confidential health information. Place clipboards face down. Do not leave printed copies of protected health information unattended at a printer or fax machine. Verify the number dialed before faxing personal health information. Encrypt personal health information when transmitting by email. Limit access to protected health information to those authorized to obtain the information. Require healthcare providers to have passwords to access a client's electronic chart. Post or provide a notice informing clients of their rights to privacy regarding their health information. Lower voice levels to minimize disclosure of information when, for example, discussing a client's condition over the telephone, giving a report, or reading information aloud from a computer screen or chart. Ensure that healthcare providers stay current with HIPAA regulations. One of the major alterations in how healthcare is practiced in this country may be attributed to the Health Insurance Portability and Accountability Act of 1996, HIPAA. The HIPAA regulations were instituted to protect the privacy of individuals by safeguarding individually identifiable healthcare records, including those housed in electronic media. Protection of individual medical records extends not only to clinical healthcare sites but also to all ancillary healthcare providers such as pharmacies, laboratories, and third-party payers. Each healthcare provider dealing with client healthcare information must, by HIPAA regulations, provide for secure limited access to that information. This is accomplished by restricting access to only those individuals who truly need to possess the information to aid the client, by locking documents in file cabinets, and by limiting access to computerized healthcare files. The regulated privacy has altered the way healthcare providers share information. Each client is provided a notice of privacy practices for each type of healthcare provider. These notices clearly state how and under what conditions individual healthcare records will be shared with other persons or agencies. Violation of HIPAA regulations by healthcare providers or agencies can result in heavy fines for this breach of trust. Intent of HIPAA regulation provides individuals with more control over their health information. Establishes limits for appropriate use and release of healthcare information. Requires healthcare providers and their agents to comply with safeguards to protect individual privacy related to healthcare information. Delineates a set of civil and criminal penalties holding HIPAA regulation transgressors accountable for actions if a client's healthcare privacy is violated. Clients' rights include the right to do the following. Inspect a copy of PHI. Ask the healthcare agency to amend the PHI that is contained in a record if the PHI is inaccurate. Request a list of disclosures made regarding the PHI as specified by HIPAA. Request to restrict how the healthcare agency uses or discloses PHI regarding treatment, payment, or healthcare services, unless information is needed to provide emergency treatment. Request that the healthcare agency communicates with the client in a certain way or at a certain location. The request must specify how or where the client wishes to be contacted. Request a paper copy of the HIPAA notice. Healthcare agency use and disclosure of PHI. The healthcare agency obtains PHI in the course of providing or administering health insurance benefits. Use or disclosure of PHI may be done for the following. A. Healthcare payment purposes. B. Healthcare operations purposes. C. Treatment purposes. D. Providing information about healthcare services. E. Data aggregation purposes to make healthcare benefit decisions. F. Administering healthcare benefits. Uses or disclosures of personal health information. Compliance with legal proceedings or for limited law enforcement purposes. To a family member or significant other in a medical emergency. To a personal representative appointed by the client or designated by law. For research purposes in limited circumstances. To a coroner, medical examiner, or funeral director about a deceased person. To an organ procurement organization in limited circumstances. To avert a serious threat to the client's health or safety or the health or safety of others. To a governmental agency authorized to oversee the healthcare system or government programs. To the Department of Health and Human Services for the investigation of compliance with the Health Insurance, Portability and Accountability Act or to fulfill another lawful request. To federal officials for lawful intelligence or national security purposes. To protect health authorities for public health purposes. To appropriate military authorities if a client is a member of the armed forces. In accordance with a valid authorization signed by the client. Self-care alert. Nurses must protect their own health and private information just as clients do. Be sure your personal health care team provides you with the appropriate HIPAA documents and safeguards your privacy. And remember, privacy regulations apply to care of all clients, even those who happen to be friends, family, or co-workers.